This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
That the investigation of CBI case number so and so revealed that every OMR answer sheet was scanned twice to avoid any chance of error. Now, during the process of scanning, two different files were generated as a result of such scanning. One was the JPEG image file format of the OMR sheet. Now, this is the JPEG image of the truncated JPEG image which has been annexed in this affidavit, Lordship. Now, the second file bearing barcode number as its name, while the other was the answer string in the format of .dat or .xls. The generation of answer string in .dat or XLS format was an automatic process, debarring any human interference, Lordship.
So, according to you, whatever is done is rightly done.
Lordship,
This is what it suggests.
what ideally should have been done is that there were some error. Admittedly, there were some error, while the JPEG image should have captured the complete
OMR.
periphery of the OMR, Lordship. All the magnetic resonance, because it is general knowledge, Lordship, that OMR, however, there are numeric values which are inputted by the respective candidates, but OMR or the computer, as in we may call it, can only resonate the magnetical resonance, Lordship. Apart from that, the inputs which are there, apart from the magnetical responses, those are not captured. And that is exactly what has been done in this case. But somehow there were an error apparent, because of which the image has been truncated, Lordship. However, the second file.
No, see, whatever is the error, at whose part, I do not know.
Lordship.
Can the petitioner be given the benefit of doubt? I do not know. It is for the CBI to say. The commission will also not have any say in this matter. If you insist that whatever is there is correct, because that is what is mentioned over here, it was scanned twice to avoid any chance of error. That means it is proper.
Is proper.
Right? Whatever you've done is proper. If that be so, no scope of giving any.
May I say this subject to Lordship convening? That Lordship, the scanning process, the process of scanning was done by the NISA or the data scan type.
Whoever.
Lordship. Now, during the investigation, what has been revealed is that the answer string, no matter the JPEG image is truncated or it's non-truncated, but the answer string has to be corroborated to the inputs which the candidate has given to its respective OMR, Lordship.
And
Now that
inputs in all the questions.
All the questions, Lordship.
That was taken into consideration.
Lordship.
So it means that whatever you found is correct.
Lordship. And that is exactly what is reflecting in page number 9 of the affidavit, which is that Annexure B, Lordship. That out of 60 questions, petitioner only attempted 15. The numbers of those respective 15 answers are also been mentioned over there. Like, if your Lordship can kindly accept M3.
All right. Whatever is there.
And out of the 15 attempts, there were some errors. So there were some negative markings. So that's why he got only
8.
8. Now,
Disqualified.
Right. Now, his total number as per the server of the commission, it was 54, Lordship. Now, prima facie, when the investigation was taken up and there was this disparity was taken up, prima facie it was held that such numbers could not have been achieved. Because he did not attempt even 54 questions, isn't it? That is exactly my way of submission. And one more thing, Lordship.
And has the commission come up with any explanation as to how 54 could be awarded to him? No.
Lordship has not directed, perhaps.
No, not over here. This matter is going for a long time.
No, before the Honorable Division Bench, as well as before the Honorable Supreme Court, that contention has never been clarified, Lordship. In fact, the one affidavit which has been filed by Central Bureau of Investigation before the Honorable Division Bench over here, the excerpts of it has been
Group D
made available in the judgment as well. So that contention,
There is nothing.
there is nothing.
All right.
And one more thing, Lordship, is that if I may say that the computer cannot. In fact, I heard my submissions by my learned friend for the petitioner that there was a possibility, may have been, that the answer script or the OMR sheet may be torn, or it may have been the half part of the OMR has been lost or something like that. But when the OMR has to be read, it has to be read in its complete entirety of it. If the half part of the
Well, all right.
May I make
Yes,
submission? Yes. My learned friend will kindly take para 11, page 5.
Yes.
the read.
No, report filed by the CBI. That as per the aforesaid answer string of the petitioner, he attempted only 15th answer out of 60 number of question. Why this 15 answer, my lord? They says it. Kindly turn page number 8. My lord, this is another Spartan, my lord, OMR sheet. Each column consists 15 answer key. Each column. They just scan the last column. It contains 15. Other column never scanned. Why I say so? Kindly take my writ petition, my lord. Order is annexed. The apex court judgment is annexed. Where, my lord, another affidavit filed by the CBI is quoted in para 22. The relevant page number 71. The judgment start from, that is, my lord, page number 49. Judgment start, the Supreme Court judgment. Para 22. My lord, I just keep it. Sub para 6.
See, the criminal case that is pending.
Yes. My lord, my contention, I'll make submission in the light of one judgment and another one statute. What is information? Under Right to Information Act, information is defined, and every statutory authority in the electronic form, they are bound to store that electronic form document for 20 years. That's a statutory provision.
Yes.
My right is that, my lord, not the first time in pursuance of court order, they published a list where my marks was there, but what was my actual OMR sheet, that marks was not given. My lord, kindly turn. I just showed 2 pages, my lord, of my repetition. Kindly
it
turn
was
page
not
number
given.
40.
You have shown me it's blank.
Second, my lord, thereafter I made the RTI application.
It is blank. It is blank. I remember that.
So, my lord, my contention is that, my lord, they failed to.
Did you appear in this year's examination?
I want to appear. My lord, may I suggest one thing? Keep pending of this writ petition, my lord.
Yes.
I want to participate in this upcoming selection process, because this is a group that is first SLST 2025, my lord.
And
that
the
teaching staff not yet held, my lord.
Started.
This writ petition is all about to participate in
Yes.
the upcoming ensuing selection process, my lord. I
Okay.
want to participate it. Let's give an interim order that I can participate subject to outcome of this writ petition, my lord. That's my humble, because
All right.
benefit of doubt.
And tell me one thing. The criminal case that is pending.
Yes, pending. I want to participate it.
You challenge or defend whatever you do over there also.
Yes. I will
Because-
take step, because even in the division bench judgment, my lord, our High Court judgment, there is a specific direction upon the statutory authority, that is CBI. You call every candidate. I want to participate in the investigation.
All right.
I will give every help.
Commission.
Regarding the issue which is being sought to be.
You do not have a say. Whatever the commission finds, the CBI finds, you have to act. Now,
his name figures in any of the lists in terms of your lordship's order, in terms
it
of
will go out as and when.
undertaking given, my lord,
As and when it is be found, he'll go out.
will go out.
আচ্ছা আসুন তো দেখে
Taking the point of fence sitter, lordship.
No, no.
fence sitter, why?
Learned friend today is submitting, my lord, that today whatever he is submitting, I was telling her,
No, I made my application.
if these submissions come previously, my lord, then perhaps all these persons wouldn't have lost.
No, that is
Which persons?
The jobs persons, 26,000 are not, my lord, tainted.
No,
they are carried-
this is only regarding half OMR.
Yes.
The truncated
Truncated
OMR. The
OMR.
court is not going into other issues.
Yes.
It is only the truncated OMR. Acha.
Only one candidate.
Only one. He
The
is the
matter
only
relates
candidate out
to-
of the 26,000.
First SLST. Within bracket non-teaching. Conducted by the commission. Step. As the name of the petitioner features in the list of tainted candidates, comma, he is not being permitted to participate in the selection process. Step. It appears that the petitioner was initially appointed in the 2016 recruitment process and his service got terminated by virtue of the order passed by this court, affirmed by the Honorable Supreme Court in the matter of Boishaki Bhattacharya. ঠিক আছে? Next. Learned advocate for the petitioner submits that the name of the petitioner ought not to feature in the list of tainted candidates, as his OMR sheet of the earlier examination could not be traced out in entirety. Stuff. Only a portion of the OMR sheet has been relied upon by the CBI. Stop. Next. Prayer has been made to direct the commission to permit the petitioner to participate in the recruitment process, however, subject to the result of the instant writ petition. Step. Next. The commission has filed, not commission, the CBI has filed a report in the form of affidavit. By the OMR sheet of the petitioner could not be found in its entirety. Stop. The OMR sheet which was found was scanned twice to avoid any chance of error. Stop. Next. From the marks ascertained by the CBI, the petitioner secured only 8 marks out of 15 questions that he answered. Stop. In the commission's list, now in the list published by the commission, comma, it has been shown that the petitioner secured 54 marks. Stop. There is no document wherefrom it can be revealed that the petitioner actually received 54 marks. Stop. Next. For deciding the issue in question, comma, hearing of the
Okay.
Stands adjourned for the time. As an interim measure, the commission is directed to permit the petitioner to participate in the recruitment process, subject, however, to the tainted list. This is only because giving him the benefit of doubt.
But we are objecting to this. But we are. But that amounts to a final relief.
No, not final relief. Whatever marks he receives in this examination will be subject to the result of this writ petition, which is being kept pending, and this order is being passed only in respect of a single candidate whose marks have not been shown in the list which has been published by the commission. No marks has been shown. This is only the reason. There is no other reason. Not that a tainted candidate is being permitted. If it comes that he is a tainted candidate, his service will automatically go.
But we are treating him as a tainted candidate. We have given him
Right.
name.
You are
His name is.
treating
My lord, kindly see,
him
appreciate
as a
this.
tainted candidate
My
on the
lord,
basis of a truncated mark sheet.
That is on the basis of the report of the CBI.
CBI,
My lord,
absolutely,
my lord, kindly
absolutely.
excuse me, my lord. These are everything was before the Supreme Court. The in other side, Mr. Samim was there. They have challenged it. Mr. Samim challenged that. This was there in earlier also.
No,
Therefore,
was
my
this
lord, today-
truncated issue there before the court?
No, they have not raised the issue.
Not
Nobody has
they,
raised
it
this.
is only one.
Kindly appreciate this, my lord. Kindly appreciate this tainted list was ultimately approved by the Supreme Court.
Sir, there is only one candidate in the list, not the entire list.
I understand, my lord, but this was done. Then, my lord, it will be just overreaching the order. My lord, excuse me for submitting. Excuse me, just submitting. This will be amount to overreaching the order of the Supreme Court.
You please tell me whether the truncated OMR sheet was before the Supreme Court.
My lord, this point was he didn't raise when the matter was going on there at that point of time.
But then did the Supreme
But
Court
he
look
had
into this
taken.
issue?
No, kindly appreciate this. Division bench has given an inspection of all documents, and they have inspected it. At that time, Mr. Samim, as a counsel, said they are tainted.
I can understand. All tainted.
Kindly appreciate this, my lord. When the matter issue was before the division bench here, that time it was everything was shown, including the LS truncated list, truncated answer paper, OMR. That time it was not raised.
I do not know whether
And-
this truncated issue was there or not. It is only because of
My
that
lord,
the court
kindly
is
one
not
thing I am just-
interfering.
my lord, one thing I am requesting your lordship, my lord, kindly do not pass an interim order. This stage of the accepting applications have been gone. That days have gone.
The petitioner has not been permitted to file the application form also.
Yes, he has not filed.
I filed this
He has not
petition
filed.
before the last date to
No,
participate.
he has not filed. He is coming now
That's
at this
my case,
stage.
my lord. Because
That
they
your case you
charged
could
me
have
as
earlier.
a tainted
The
candidate,
problem is
and
this,
I
my lord,
made
one
an
person is
RTI
taking double
application.
stand.
Kindly see my
Somewhere
RTI
one stand,
application.
somewhere is
Page
another stand.
47. Page 47. Before the West Bengal Central School Service Commission. They were
Therefore, my lord,
silent.
kindly do not, kindly do not,
What step I taken being a candidate, my lord?
kindly no,
First-
his application was not there.
My lord, firstly, my lord, that issue was not there. When they
And
published
he
the
has,
list,
he is,
my
whatever he is making his
1 minute,
submission,
not. Yes,
he,
Mr. Bandyopadhyay.
whatever he is making his submission on the basis of the RTI information.
Yes.
And everything had been destroyed.
No. The scan reports are there.
My lord, kindly say one thing, appreciate this. My lord, kindly excuse me. The list of the, my lord, this, what is called, tainted list, along with this, that was placed in the High Court and also the Supreme Court. The Supreme Court has said nobody will get from that place. If he is at any grievance, he can make the application before the Supreme Court. But if any order is passed with great respect, I am submitting, my lord, kindly do not do it, my lord. My lord, I am submitting, kindly do not do it.
In
Let
that
them
case,
take
I
the
dispose of
clarification
the
from the
writ petition here and now, because I don't think the court can decide this issue. Whatever is to be done is to be done by the CBI. It is not for this court.
May I make submission? Because if my lord wants to finally dispose of, my lord, take my submission, my lord. Why, my lord, I say so?
This was published on 13th August
I make my
2023.
submission. Thereafter, you will
13th August 2023.
my lord, may I?
That is at page 39.
points was
Can you see
taken.
page 39?
One is
He is
Fensita.
coming in 2026.
Another point is that, my lord, my name is featured in the tented list. I challenge it. Why I say so, my lord? Kindly turn page number 39. First,
Yes.
this is a list, my lord, which was published in pursuance of the court order. Kindly turn page number 42. I just
40?
2.
All right.
My name entered 2442.
Hmm.
Roll number is there.
Hmm.
Thereafter 54, that is published OMR marks.
Hmm.
If I tell it from first page,
Hmm.
actual OMR marks blank.
Hmm.
What step I taken, my lord? Kindly see, my lord, I made representation. I just keep it for the time being. Page number 45, 46. Page number 47 is my RTI application.
All right. Tell me one thing. This list was published in March 23. What steps did you take thereafter?
Thereafter, I was in service. I still, my lord,
Yes.
because of that 3rd April 2020, up to 3rd April 2025, I was in service.
Yes.
My service was never terminated.
Right.
So I was in service. Whatever list is published by the School Service Commission, that will not curtailment of my right.
Hmm.
When my right was curtailed in pursuance of 3rd April 2025. Thereafter, my lord, I took step, my lord. And not only that, my lord, in the year 2023, kindly turn page number 45, my lord, 7th June 2023, I made this representation before the West Bengal School Service Commission. What I wrote, my lord, kindly may I read it, my lord? আমি শেখ সানিউল্লাহ 2018 সালে ক্লার্ক পদে জয়েনিং করেছিলাম। আমার অ্যাডমিট কার্ডে রোল নাম্বার সাচ এন্ড সাচ। গত 9/3/2023 তারিখে মহামান্য হাইকোর্টের নির্দেশে এসএসসি যে ওএমআর প্রকাশ করেছিল তাতে আমার সিরিয়াল নাম্বার ছিল 2512, কিন্তু এসএসসি ওয়েবসাইটে আমার ওএমআরটি দেখতে পাচ্ছি না। পেজ নট ফাউন্ড। The resource you are looking for has been removed or temporarily unavailable দেখাচ্ছে। গত 13/3/2023 মহামান্য হাইকোর্টের নির্দেশে এসএসসি যে মার্কস ডিটেলস দেখানো হয়েছে তাতে আমার সিরিয়াল নাম্বার ছিল 2442। সেখানে আমার মূল ওএমআর মূল্যায়ন নাম্বার 54, বাকি জায়গায় ফাঁকা রাখা হয়েছে। That means, my lord, two lists was, one is the OMR sheet published by the SSC in the year 2023 in pursuance of court order, and another thing is marks was given. মহামান্য হাইকোর্টের নির্দেশ ছিল প্রার্থীর প্রথম ওএমআর শিট প্রকাশ করতে হবে, তারপর নাম্বার ঘোষণা করতে হবে দেখানো। যদি কোনো অসঙ্গতি লক্ষ্য করা যায় তখন ওই প্রার্থী বাতিল, কিন্তু আমাকে আমার কোনো কিছু না দেখিয়ে বাতিল করা হয়েছে। মহাশয়, আপনার নিকট আমার বিনীত নিবেদন, আপনি আমার সমস্যাটি সমাধান করিয়া দিলে বাধিত হইব। ভেরি নেক্সট পেজ, 12 July 2023, I again wrote a letter to the SSC. What step I taken, my lord? I just show one after another. আমি শেখ সানুল্লাহ 2018।
Listen, all said and done. Fact remains, it is for the CBI to find out whether.
With deepest of respect, may I say one thing? This is all about, my lord, OMR sheet evaluation by the Article 12 authority. First OMR sheet evaluation done by the SSC. Thereafter, my lord, after all these things happened, to identify the tainted candidate, CBI did it. Now CBI in the form of affidavit, report in the form of affidavit, they first time I saw my OMR sheet, this truncated OMR sheet. From this truncated OMR sheet, it never established that I am a tainted candidate. Well, they are tainted list. The SSC's tainted list is not a sacrosanct list. That list might enlarge, because ought to enlarge, because I can show from here and now, from the judgment itself, that list ought to enlarge, because 7,000 more list ought to be published, but they only published 3,500 odd numbers. my lord, my respectful submission is this, my lord. What the first time I saw my OMR sheet in this every report, from this report, it is evident that this OMR sheet is not mine. Why? Because of that, OMR means full OMR. And not only that, I made a RTI application.
No, it's all right.
The information.
All said and done, the CBI is the investigating agency and the criminal case is pending before the court. You, till you can bring your name out of the list, it will be difficult for you to stay in the job, even if you participate in the recruitment process, right?
Why I asking for the interim relief? Because of that, by that time, my lord, the selection process
Maybe over.
Maybe over. Maybe I establish myself.
Why don't you oppose?
That time, that OMR sheet is not there, my lord, because they never published my OMR sheet.
No. In terms of the division bench order, Justice Bosak was pleased, Honorable Justice Bosak was pleased to pass an order to take inspection of all the OMRs. That time he didn't take the inspection.
What can I do?
He didn't take the inspection.
What is my
this order was passed
on
that order was passed at the instance of Mr. Samin.
It was a mere visibility. But when my
that order was passed by at the instance of Mr. Samin.
Half OMR sheet when the leave was granted to you.
No. My lord, what happened, my lord?
No, did you see the OMR?
No.
Why?
It was never given to me. That's my case. My lord, kindly see my representation. That's my case. That OMR sheet was never given to me. That's why time and again I made the representation. Why not only that, I made an RTI application to get my OMR sheet because I covered by the definition of information. They ought to preserve that information for long 20 years. They failed to do so. My lord, benefit of doubt must be given to me. And my lord, if they says that no, we will never give you the information and I will adjust you as a tainted candidate, that is not tenable. They ought to give my information. It's my statutory right. Until and unless you give the information, you feature me as a tainted candidate. Well, this tainted terms came out.
He cannot establish his right after 3 years.
Respectful submission.
He cannot establish his right after 3 years.
The tainted terms came out in pursuance of the information given by the CBI, which they collect from Pankaj Bansal house. What they collect, in my case, a truncated OMR sheet. This OMR sheet must not establish that the candidate itself is tainted one, my lord. My respectful submission is that, my lord, heaven will not fall upon this, my lord, in these cases, my lord. My lord, kindly allow me as an interim measure subject to outcome of the writ petition. If I will not succeed.
No, what can be the outcome of this writ petition? This is what I was thinking. Because the court cannot decide whether your OMR is proper or not.
May I see a separate part, my lord, because of that, my lord. We give an interim measure to participate in the selection process. In this case, my lord, if I came out in the criminal cases, because this is a unique case, it is happened only for one candidate, for 22 lakhs candidate, out of this 22 lakhs candidate, my lord. This is the only example. So, my lord, my respectful submission is that, my lord, give me an opportunity to participate in the selection process. If I came out from the criminal proceedings, yes, I am an innocent one, then only give appointment, otherwise not. My lord, that's my respectful submission.
No further evidence will come. However, Mr. Samin has argued the point only one.
My point
This is the one person was there. According to his argument, that judgment was passed.
Suppose
How will
if in the
complete
criminal proceedings I establish myself as a innocent one, then my right will go.
He is arguing a complete
equal opportunity, public employment. That's my constitutional right, being a citizen of India. The article
citizen of India doesn't enjoy 3 years
to produce my OMR sheet. They canvass me as a tainted candidate. Whereas, my lord,
may I make one submission?
Renounce my right.
That is allowed, that amounts to, Lord, with great respect, I am saying it. Just kindly take it from me. I am just with great respect. I am saying it will be overreaching the order of the Supreme Court. If he wants to take it from the Supreme Court. I have no problem. Your Supreme Court, I have given an undertaking. Not a single one will be there. If anyone points out, and if I found yes,
handed by judgment, my lord.
The name of the delete the name. And after 3 years, he is coming, 23 years, given the representation. That is also delay.
It is published in the 2023.
He has not taken the inspection. That order was passed by Justice Bosak at the instance of the Mr. Samim's argument.
Published on
13 March 2023, it is published, my lord.
No, the list of tainted candidates was published when?
After the 3rd April 2025.
No.
That is 3rd April.
The inspection was given
Before
when the
that,
division
when
bench matter was
proceedings
going on. Your judgment order. Down, bhai.
That this is not a tainted candidate list. Well, kindly read it
This
because
is not a
this is
tainted
my matter because I know it
This
very
is
well.
not a tainted candidate
This
list,
is
I
a
can
list.
understand.
This is because CBI filed a report. From that report, it is evident some person's name was some person got higher marks from the actual marks, my lord. That list is there, my lord. In that list, my marks was not there. That's why I made the representation. And at that point of time, court also says you ought to publish the OMR sheet. They failed to publish my OMR sheet. Thereafter, I made this representation.
See, all said and done, till your name is not removed from the list of tainted candidates, you do not get a chance, right? Now, you have to take steps to get your name deleted from the list of tainted candidates.
Because of that, I came before a
That paragraph 307 of the judgment. Just can I read two lines? Can I read 2 lines, my lord?
I may submit it because of that, my lord. It's my right, my lord. Because I have twofold right, my lord. One is that, my lord, that a constitutional right, my lord. Equal opportunity in public employment. I want to secure that right because, my lord, participation in a
Cannot get that right if your name remains in the list of tainted candidates.
My lord, they failed to produce my OMR sheet. They failed to establish me as a tainted candidate, my lord.
Right.
My respectful submission is that because primarily, my lord, kindly take care on that. What is the basis of the Supreme Court judgment? That is para 22. My lord, kindly see para 22. From para 22, it is evident. My lord, may I read it, the para 22 again? From para 22, on the basis of the CBI affidavit, that order was passed. That affidavit, they clearly mentioned, my lord, kindly see page number 71. Sorry. 72 is the relevant one, subpara 6. This, my lord, we have just, I read the 4 line of the para 22. We have 4 reports submitted by the CBI. We would like to quote some of the passages from the report dated 5th February 2024, submitted by the CBI in compliance with the order dated 24th January 2024, passed by the High Court at Calcutta. The relevant portion of the said report reads as under. Just I skip it. Subpara 6. That while scanning the original OMR by Messrs. Data Scantex Solution on behalf of the Messrs. NISA, 2 DAT file were generated containing scan number, barcode, roll number, venue code, booklet serial number, subject code, category, gender, medium, response codes. Kindly see other actual OMR sheet. It never be scanned until and unless you furnish the whole OMR sheet. On the basis of that affidavit, on the basis of that, Supreme Court presumed that that evidence is genuine evidence. Whatever data was given before the apex court on the basis of the actual data. But for this petitioner, that data was not there. That fact was not before the apex court. Because on the basis of this affidavit and others affidavit, the Supreme Court passed that judgment. So, my lord,
public notice were issued by the division bench.
quoted in the judgment itself that
participated in that.
petitioner, that data was not there.
Dr. Sandy, kindly lift up page 9
Public is there.
of the evidence.
High Court, at paragraph 307, it has been very clearly stated in judgment that just I read it, factum, validity, legality, sufficiency, authenticity of the data stored in this hard disk has been proved by the conduct and actions of the relevant Article 12 authorities. Subsequently, the seizure of the 3 hard disks, and after CBI had shared such data with the relevant of the CBI has given inspection to such of the parties to the proceedings who wanted to inspect of the data stored therein, relevant to the copy, claim of the custody of the 3 hard disks from the time to time, seizure thereby CBI till inspection, given the data stored therein. There was got the chance of the inspection. There was a public notice. He did not participate in the public notice. The issue which has been settled down by the earlier proceedings, he is now in a truncated way, he is raising the point.
একটু পড়ুন না উপর থেকে, আর একদম গোড়ার থেকে পড়ুন।
In the selection process, it appears that the petitioner was initially appointed in 2016 recruitment process and his employment is got terminated order passed by this court confirmed by the Honorable Appellate in the matter of Bolshali Bhattacharya. Learned advocate for the petitioner submits that the name of the petitioner was not to figure in the tainted evidence as his OMR sheet of the earlier examination could not include only a portion of the OMR sheet has been elaborated by the CBI. Prayers have been made to direct the Commission to permit the petitioner to participate in the recruitment process, however, subject to the result of the instrumented petition. The CBI has filed a report in the form of an affidavit disclosing that the OMR sheet of the petitioner could not be found in its entirety. The OMR sheet which was found was scanned twice to avoid any chance of error. Ascertained by the CBI, the petitioner secured only 8 marks out of the 15 questions that he entered. In the list published by the Commission, it has been shown that the petitioner secured 54 marks. There is no document wherefrom it can be revealed that the petitioner actually received 54 marks. For deciding the issue in question, hearing of the requisitions.
এখান থেকে কাটুন। The Honorable Supreme Court, in the matter of Boishaki Bhattacharya within bracket Supra, made it explicitly clear that any candidate who features in the tainted list cannot be permitted to appear in the examination to be conducted by the Commission for filling up the vacancies. Stop. Though the petitioner asserts that that his name was incorrectly incorporated in the list of tainted candidates, but as the petitioner has not yet been able to remove his name from the list of tainted candidates, accordingly, this court is not agreeable to pass any order in favor of the petitioner permitting him to participate in the selection process. Stop. It will be open for the petitioner to approach the competent forum for taking appropriate steps for removing his name from the list of tainted candidates. The writ petitions.
Just add one line, it will not preclude this writ petitioner to institute because of that. In that occasion,
preclude the petitioner
to institute a new case. Because why I say so? Because otherwise, my lord, this writ petition.
mentioned.
But suppose because
What
they will say,
not
I
if-
want to participate in the selection process.
Hmm.
They will, the constructive res judicata point might be taken by
Hmm.
by the Article 12 authority. It will be, we made it clear, my lord.
কি বললাম?
Made it clear.
The petitioner to approve the competent forum for name from the list of tainted conditions.
Only if the petitioner is successful in removing his name from the list of tainted candidates, then only his right to secure appointment or participate in any recruitment process will arise. And the dismissal of the writ petition will not be taken as a constructive res judicata in that case.
Extremely grateful, ma'am.
Take this back. I have a copy.
I'm extremely grateful.
Dismissed. Writ petition dismissed.
Extremely grateful.
Grateful, ma'am.
There is a supplementary list published.
No,
Yes.
From the daily